U.S., the Supreme Court agreed to hear oral arguments in a major pro-life case in their next term, next fall, Dobbs versus Jackson Women's Health Organization, which concerns a Mississippi law banning abortion procedures after 15 weeks. Lower courts blocked the law, but the state of Mississippi appealed the ruling to the Supreme Court. Here with analysis of this case, as well as an important new law signed in Texas this week, is Carter Snead, professor of law at the University of Notre Dame. Carter, you've seen the media coverage. Some of it claims that this Supreme Court case imperils Roe v. Wade. How far-reaching could this decision actually be?
Well, the specific question the court has agreed to answer is whether or not any restriction on abortion prior to viability is unconstitutional. And if you read Roe v. Wade and Planned Parenthood versus Casey, a fair reading of those precedents is that, yes, a total ban on abortion prior to viability under those precedents, at least as they've been applied by the lower courts, has been taken to be unconstitutional. So I don't see how they uphold the Mississippi law without significantly modifying, if not overturning, Roe v. Wade and Planned Parenthood versus Casey.
Wow. Now, I was told by some court watchers and reporters just the other day that this is really about the viability question and when you can prohibit abortion because of the new technology we have today with ultrasounds and heartbeat monitors, that they can detect when that fetus is viable and therefore making that the cutoff point where you can legalize abortion. So anything prior to that would be legal, anything after illegal. So you don't think it's that narrow? You think the implications here could be far broader?
I think it's very significant, yes. I mean, we've seen a cascade of laws, all of which apply pre-viability. We've seen heartbeat laws like the one in Texas that you mentioned at the outset. This law is a 15-week ban. There are other bans on reasons for getting abortions to eliminate children with Down syndrome or for sex selection or to eliminate a child of a non-preferred race. All of these apply pre-viability. And so I think we do need a significant revision in the jurisprudence in order to sustain that. And I'm hopeful that with 6 justices on the court, who all of whom understand that Roe v. Wade was basically a castle built on sand. I mean, they try to situate a right to abortion in the 14th Amendment Due Process Clause, which was ratified in 1868 when abortion was illegal everywhere. And no one thought that it had anything to do with the state's authority to protect unborn children. I think it's long past time the court took action on that.
Well, this, as you mentioned, this is the first abortion case since Justice Amy Coney Barrett, your former Notre Dame colleague, was confirmed. It's also a real test to the court's new 6-3 conservative majority. Given that makeup, how do you think this will go if you had to look into the future? And I know I'm asking you to go further than you'd probably like to.
It's an impossible question, of course. I mean, you never know how justices are going to rule. A lot of us in 1992 thought the Supreme Court was poised to overturn Roe v. Wade when they issued the decision in Planned Parenthood versus Casey to affirm what it described core holding of Roe. I think that put it this way, there are 6 justices on the United States Supreme Court right now that I surmise, I have no inside information, I don't know what anybody actually thinks, but based on their record and based on their judicial philosophy, it's hard to imagine any of those justices believing that the 14th Amendment controls a secret right to abortion that has all of these Byzantine dimensions, pre-viability, post-viability, trimester framework, et cetera, et cetera. It's just not in the Constitution. And to say that it is a kind of constitutional violence. And it's hard for me to imagine that those 6 justices know or would disagree with that proposition, that that none of them, I don't believe, think that as a matter of original understanding or plain meaning or anything, any legitimate form of constitutional interpretation, that there's a right to abortion. So the only question for the justices is, what do you do about it? Do you let the law stand? Do you let those precedents stand because of the doctrine of stare decisis, or do you act courageously and decide that enough is enough? Our country, our politics has been ruined for almost 50 years. Our judicial confirmation process has been ruined. Our polity is completely polarized. Why not take a courageous step and apply the law as it's written, as it's originally understood, and undo this travesty that has been in place for almost 50 years? As I point out in a Newsweek column today, the cert was granted in this case on the anniversary of Brown versus Board of Education, May 17th, 1954, in which the court was, told that they were going to disrupt an entire system of education by striking down the concept of separate but equal segregation, and they didn't flinch. They did it. Yeah.
But given the media pressure, the political pressure, do you really see them overturning Roe v. Wade at this point, Carter? I mean, if you just look at John Roberts over the last few years, a little political pressure and a few op-eds in the Washington Post, and he starts running in the other direction. That does concern me. I think that is certainly an element, and won't it be an element in the outcome here?
Well, I think there's a hopeful indication in his concurring opinion in the June Medical Services case, which was a disappointing case because they struck down Louisiana's admitting privileges law. But in his concurring opinion, he makes it very clear that he does not believe that the framework of Roe and Casey that require the court to do this political balancing of incommensurable goods, freedom on the one hand versus the lives of innocent children on the other, that that's a job that the court can do. So I take his concurring opinion as grounds for some hope that he will have the courage and the commitment to principle to do the right thing.
Interesting. I'd forgotten about that concurring opinion. You're right. As the Mississippi law is written, it would allow exemptions or exceptions, rather, to the 15-week ban in cases of medical emergency or severe fetal abnormality. What happens if Mississippi wins this case? Will this have a ripple effect in other states? Others have obviously put these restrictions in place already and have been battered back by the courts.
Yeah, it depends, obviously, on what the court says. I mean, if they affirm the Mississippi ban and go no further and don't give us any further guidance, I think that would be a mistake on their part, because any abortion law gets tied up for years in court before it goes to the Supreme Court and we get some splintered decision with an oracular holding that doesn't really give states much guidance into what they're permitted to do. The only clean and principled thing to do is to say, Roe v. Wade was wrongly decided. Casey was wrongly decided. This law will stand. And then you've got a whole host of laws like the Texas law, the heartbeat bill. You have laws like Alabama's laws from a few years ago, which was just a total ban on abortion. And so, if they do overturn the case, those precedents, and they say that it goes back to the states for political resolution, we'll see a federalist solution. We'll see a patchwork of laws. New York and Illinois and California will be very permissive, and the states that have passed these laws pre-viability will be more restrictive. I think people will see, if that's the grounds on which they overturn it, that it's not the end of the world for abortion. Sad to say, for people like me, I'd like to see the end of the world for abortion. But it's just the beginning of a new phase of political disputation in which we can actually have a conversation amongst ourselves and the political branches of government and come to some solution on how to govern ourselves.
Earlier this week, White House Press Secretary Jen Psaki was asked about the court's decision to take up this case. She didn't specifically comment on the case itself. Instead, she offered general support for abortion rights. Listen.
Over the last 4 years, critical rights, like the right to health care, the right to choose, have been under withering and extreme attack, including through draconian state laws.
She also added that Biden is committed to codifying Roe in the law. Your thoughts, Carter?
Well, my first thought is it's interesting that she can't say the word abortion. She said the right to choose. It's always a bad sign when you can't even say the word of the thing that you believe is enshrined in the Constitution. That should provide, I think, confidence to folks like us who understand that it's not in the Constitution. Secondly, the notion of codifying Roe has been in the water for a long time in Washington, D.C. There's an interesting question. Well, the question is, could you do that in a 50-50 Senate when the 50th vote on the Democrat side is Joe Manchin, who purports to be pro-life? That seems not likely. Moreover, there's an interesting question as to whether or not the federal government has the authority to codify Roe. What enumerated power in the Constitution gives them the right to impose a uniform abortion policy across the country? These are hard questions. I think that they're trying to reassure their abortion rights supporters that they are focused on these issues and they're important to them because that's such an important voting bloc for the Democratic Party these days. But I think that I'm not frightened of them codifying Roe, at least certainly not with the current composition of Congress.
Texas Governor Greg Abbott on Wednesday signed into law a fetal heartbeat abortion bill. It bans the procedure after about 6 weeks of pregnancy, and it grants citizens the right to sue doctors who perform abortions past that point. Texas is now aligned with many other states that have banned abortions after that fetal heartbeat can be detected. Are federal courts allowing these state laws to be enforced? And how far does this go? Where is Greg Abbott begging the Supreme Court to crash in and weigh in on this so that you set a national precedent?
Yeah, I mean, this is interesting because that's a more dramatic pre-viability ban than the Mississippi law, which makes the question presented to the court in Dobbs even sharper, because when they know that when they're going to be answering the question, are all pre-viability bans unconstitutional, it's the Mississippi law is not the only law on the books that they're going to have to contend with. So I hope that they'll take that opportunity to articulate a rule that doesn't require Texas and Ohio and everybody else to spend time and resources litigating the details of their specific cases. So the most interesting thing to me about the Texas law, by the way, is what you said, namely that every citizen under the law has the right to enforce it and can bring claims to enforce the law across the state of Texas. It's a very interesting strategy and will likely keep these cases in state courts, possibly in very friendly state courts who might very well affirm or take steps to enforce this new law.
I want to get your thoughts on it's sort of a related story. President Biden's commission to study the Supreme Court kicked off this week. He formed the commission through an executive order to examine, quote, contemporary commentary and debate about the role of the High Court. Now, this week, the commission met for the first time virtually. For 25 minutes, they all were sworn in. The commissioners explained the 5 areas they'll be studying. Listen.
We're going to look at the justices' length of service and how frequently the court's membership should turn over. And this is going to include proposals for term limits and mandatory retirement.
And then we'll look at current proposals to expand the scope, the membership and size of the Supreme Court, and whether those proposals require other reforms. An expanded court, for example, might require a panel system for deciding cases. An expanded court couldn't possibly sit on all cases all the time.
Carter, you're a law professor. Is there any legitimate reason to study the length of service of a justice, and should we expand the number of justices on the High Court?
Well, it's been a long-standing question as to whether or not life tenure is the right standard for or the right term of office for judges on the U.S. Supreme Court or on the U.S. Courts of Appeals or district courts in the federal system. There are interesting arguments on both sides. I don't anticipate very much change on that particular question. The thing that's obvious about this is that this is just naked politics, right? I mean, there's no reason to expand the number of justices on the Supreme Court unless you're simply trying to affect different outcomes that are more favorable to you politically. And that's the antithesis of what a court is supposed to be. And the entire exercise is corrupt and should be rejected. And to his great credit, Justice Stephen Breyer has been making this argument recently and is even publishing a book making the case, which, by the way, is obvious. If we want our courts to be separate from the political branches of government, when you lose an election and you end up having certain retirements or deaths on the court and certain vacancies, and then your immediate step is to expand the majority so that your side will get a majority, or expand the number of seats to where your side gets a majority, that's a transparently, nakedly partisan act, and every person of goodwill should reject it.
Well, Carter, you're exactly right here. And the thing that when I heard Gerald Nadler this week, who is the chairman of the Judiciary Committee, he came out and said, look, we're not trying to pack the court. That's what Trump did. We are unpacking the court because right now the court is imbalanced. I mean, it seems to me when you start approaching the Supreme Court from that perspective, you're running into the separation of powers that the Constitution creates and prohibits one branch of government meddling unduly in the affairs or creation of the other, right?
It is extraordinary. Senator Mike Lee makes a joke that if they go down this road what we're going to end up with is every administration of a different party is going to expand the court even more. And then in 20 years, it'll look like the intergalactic Senate from Star Wars. I mean, it'll be a huge, there'll be 150 people on the Supreme Court, and Guam will be a state, and the Marshall Islands will be a state. I mean, it's just a grasping at power when a person is lost legitimately. And look, the Democrats control all three branches of government right now, and yet that's not, all the political branches of government, I should say. But that's not enough. They want to take steps to expand the court and enhance their power even further. And I would be saying the same thing if it was a Republican administration trying to do this. It's completely out of order, and it shouldn't be done.
Yeah, well, to say that, the one administration was packing the court, next week the Republicans will be saying Barack Obama was packing the court. No, he was duly elected, he proposed a candidate, and the Congress that you elected affirmed and confirmed those individuals. That's called the constitutional process of filling a vacancy at the Supreme Court. So this political rebranding of what it means, the size, the scope, the length of tenure, I agree with you. It seems this is all politically motivated, and we all, right and left, should reject this entirely. Carter Snead, we will leave it there, and I want to remind people to get a copy of your book, What It Means to Be Human, The Case for the Body in Modern Bioethics. It really speaks to the undergirding, the foundation of everything we're talking about today. Carter Snead is the author of that book. It's available at bookstores everywhere. Carter, thanks for being here.
Thank you, Raymond.